Let us
We are
know when
live.
you do go
Let's go.
live.
We are live.
Okay, great. Okay, hello everyone, and welcome to our 9th episode. We're delighted to welcome two special guests today. Takbir Huda, who is a human rights lawyer currently pursuing a degree at Harvard Law School and who has also worked with Amnesty International, and Shamrukh Mohideen, who runs the Bangladesh Project. The Bangladesh Project is a research and advocacy group which has been focused on Bangladesh's bilateral ties with the US and on economic development issues concerning Bangladesh. Shamrukh and Takbir will discuss today about Takbir's research on criminal justice reforms, following which there will be an opportunity to ask questions. If you have any specific questions, please type them into the chat along with your name, and we will collect them afterwards. Thank you very much for joining and enjoy the discussion. Shamrukh, please.
Thank you, Kausar Bhai, and thanks to everyone for joining today. Thanks to the Bangladesh America Alliance for hosting us. I'm delighted to have Takbir here for the discussion to discuss how to strengthen the rule of law in Bangladesh with a specific focus on the criminal justice system. He's been studying and following these issues and speaking on these issues for a while. And now that we have this critical time in Bangladesh where we have a small window of opportunity for reforms before the elections are held, I would like to get his views on what's achievable in the short term. My own work with the Bangladesh Project includes work on economic security and working with external stakeholders to build capacity in Bangladesh as well. So I'm also interested in his views on how other partners for Bangladesh can support and guide our work on transitional justice systems and how we can draw from global best practices as well. So Takbir, we'll start with a few questions for you, so we'll keep it conversational. So as we've seen after the July Revolution, when former Prime Minister Sheikh Hasina was ousted after a bloody uprising, the interim government has made some significant progress on some fronts, especially on the economic front. We've seen some of those figures come out recently, where there have been some challenges around some of the rule of law issues that we've seen lately with the incidents of mob justice. There have been some general lawlessness as well that people have been concerned about, which is actually normal in many countries that have gone through a revolutionary situation. And also where some folks within, stakeholders within the country have used the authoritarian apparatus of the state to their own interests. So we have some issues with that as well. So there's this larger rule of law issue that I think that Bangladeshis at home and are broader concerned about, and everyone wants to create a system that's robust and credible, and that will prevent us from going back into authoritarianism, right? So I think that people's trust in the justice system is paramount, which is why we're having this discussion. So I'll start off with a broad question for you in the beginning, which is, what do you think are the key problems with the criminal justice system in Bangladesh that allows for stakeholders to use the authoritarian apparatus of the state for their own interests?
Thank you so much for having me. And yes, I mean, it's important to sort of specify what do we mean when we say that there's a risk of authoritarianism. I mean, right now, after the ouster of the former prime minister, you know, it's become quite common for people to refer to fascism, authoritarianism. But I mean, there's a real risk that if we do not sort of substantiate these phenomena through tangible, metrics, it's difficult to sort of understand what needs to go. So from the point of view of the criminal justice system, I will sort of suggest that we focus on 4 particularly authoritarian powers of the state that has become increasingly normalized over the years. And the first is the power of the police to arrest people without a warrant. So, you've had a case be filed against you. The police just shows up at your house and arrests you without even a warrant, and that's possible if the case is considered a cognizable case. And then, supplementing this is, once you've been arrested, you're in detention, and then your constitutional right to bail is denied. Because again, the offense that you've been charged with is considered non-bailable. And even though a non-bailable offense is still does not preclude your constitutional right to bail, it makes it more difficult. So the judge, for instance, does not grant you bail. So then you have arrest without warrant, denial of bail. And when you have those two things, what happens is that you are in prison, you are in pretrial detention, despite any crime being proven against you. And this combination, arrest without warrant, denial of bail, lengthy pretrial detention. This formula has worked so much in Bangladesh. It's become so common that if you look at the most recently available jail statistics, the large majority of prisoners in Bangladesh are actually in pretrial detention, so around 80% or so. And these are individuals who have had no crime proven against them, but they're still in prison. And most of them have been in prison for many years. So this cannot be the reality or the scenario in a country that claims to be democratic. And I think these are specifically the powers we need to be critical of and the powers we need to limit if we are to achieve true liberation.
Yeah, thank you for those thoughts. I think that while we're working to build the foundations of democratic systems, a lot of these discussions are really important to have. And there is this larger context of how Bangladesh is being viewed by other countries, and they're determining their relationships with Bangladesh as well. So I think that seeing this robust conversation among citizens is really important to see how we can build these transparent systems. So maybe specifically coming to this issue of the punitive criminal justice system, could you talk a little bit about what the implications are of that, how they can be used for retribution, and are there other possibilities for rehabilitation or restorative justice, which I know you've worked on as well?
Right. So it's first important to contextualize where our retributive or punitive legal consciousness has arisen from. Historically, we used to have a pretty restorative system. By that, I mean, back in the Mughal era or the pre-colonial era, what we had were community-based justice systems, or what we now sort of vilify as shalish, right? Like power was decentralized. If there was something that was wrong that offended the community would respond as a collective. Sure, that system has its own issues, but the key point being that it was heavily decentralized and it was not a system of incarceration, i.e., people were able to achieve swift justice. People were able to sort of represent their own interests, and a trusted community elder would sort of determine what is or isn't appropriate in this case. And that is, in a nutshell, what sort of like the yesteryear restorative justice model looks like. Now, the great irony is that because we had such a decentralized system when we were being colonized by the British Empire, they needed to sort of consolidate power centrally. And that is the birth of the modern criminal justice system as we know it in the Indian subcontinent. And the powers that I was referring to, these all originate from colonial laws, which we have retained. So Pakistan retained them during partition when we were part of Pakistan, and then we retained them when we, seceded from Pakistan. So there's been a conscious decision on part of post-colonial rulers to retain these colonial powers. And that is why, when we speak about restorative justice, there's a real risk that people may think we're trying to impose a Western model of justice on Bangladesh, or that some kind of legal transplant is taking place. But that is why this history is important. We were actually the pioneers of restorative justice in the pre-colonial era. Such kind of retributive, punitive responses to wrongdoing is very much a colonial legacy. So at first, we must acknowledge that history. We must acknowledge that rupture. We must acknowledge that legacy. And then the question then becomes, how do we go back to doing justice in the way that we used to do? How do we escape from this carceral machine? And that's where, we could sort of look at what's happening around the world. Like, this is a trend that most advanced legal systems have come to. Like, they've by and large concluded that a system of incarcerating people, a system of imprisoning people, a system that is predicated entirely just on retributive notions of justice, these systems do not make societies safer. They do not make victims feel any sense of justice. They do not address victims' needs. So there are many restorative justice programs that are being developed across the world. New Zealand is the most telling because they've sort of adopted the Maori, indigenous communities' justice principles, which are very similar to the ones that I was describing, and made restorative justice mandatory for anyone who is under the age of 18, so for all child offenders. So examples are there if we're willing to learn from it. So we can learn from current practices around the world, but more importantly, we can also learn from historic practices within our own land. So the idea being that, when a wrong has happened, the more important question is to ask, how can we restore the victim to a pre-crime situation, like to restore their dignity, to restore their rights, what needs to happen to meet their needs, rather than asking, who can we punish, who can we hang, who can we lash to death? Yes.
Mm-hmm. Yeah, those are really important questions that you raise, and it's really important to understand the historical context behind it as well. So thanks for laying it all out for us. You mentioned the pretrial detention issue and how long it takes sometimes to get to access to justice for perpetrators as well as victims. So I was wondering if there are ideas that you have in terms of how to expedite some of these processes. Is it a matter of state capacity? Are there other bureaucratic hurdles that we're dealing with? How do we actually make sure that these pretrial detentions aren't really long, where there isn't maybe credible evidence against some of these perpetrators as well?
Well, on the issue of pretrial detention, it's not happening because of a capacity gap. It's happening because we think it's normal to incarcerate people as soon as a case has been filed against them, but it hasn't been proven against them. So this is what allows the criminal justice system to be weaponized. So when the former Awami League regime was filing cases in mass scale cases against its dissidents, against its political opponents, it did not seek to create cases which would ultimately be able to show that these individuals committed the crime beyond reasonable doubt, which is the evidentiary question. Their objective was very much to trap them in a system of pretrial detention until they needed them to be, for as long as they needed them to be in prison. So this shift in the objective of the criminal justice system, which originally used to be to prove crime against people who could reasonably be suspected of having committed crime, to this system where it's not relevant if they've actually committed the crime. What's relevant is how long can I hold them in prison without any credible proof? So this shift happens when the criminal justice system becomes weaponized, and when the features within the criminal justice system allows that shift to take place, which is why we need to get rid of laws which make it possible for the police to arrest people without warrant so easily. We need to get rid of the legal provisions which make all increasing number of cases non-bailable. We need to essentially have a target reduction rate for our pretrial detainees. That already exists as part of the Sustainable Development Goals, which we've committed to achieving by 2030, like Goal 16 of which requires a certain reduction in the rate of pretrial detainees. So, that monitoring is already happening as part of the SDG reporting process. But in relation to the other systemic capacity issues, justice spending needs to increase, right? You can't just have random directives saying that you need to finish investigation within X amount of time if you're not also accompanying that directive with some kind of institutional expansion or appointment of more judges, appointment of personnel. The investigation isn't stuck in a limbo primarily because police are just, chilling. There's a real crisis gap. There's a real crisis of resources. We don't have the metrics, but it would be nice to sort of understand what the judges per capita is, or what the courts, how accessible courts are. We did have a 2015 survey from UNDP measuring access to justice, and by and large, the figures there were quite dreary. So, justice spending definitely needs to increase if we want to make access to justice a more discernible reality.
Mm-hmm. Those are really important thoughts, and we do want to prevent the nation from backsliding into this vicious cycle as well, right? Where each party that is coming into office is using this apparatus to kind of go after the others that they don't like and the opposition. So that's the cycle I think that everyone's tired of and they're hoping to come out of. So these are really important points. Moving into this question of mob justice, I know that many of us have been following these issues that have been cropping up, and now I think more are also being reported because we have a relatively freer media. So I was wondering if you have thoughts on whether the rates of mob justice are also rising. Is there an actual uptick? And how do we prevent people from taking law into their own hands, and what are some of the pitfalls of that?
Right. So it's actually very difficult to answer with any empirical certainty whether crime or mob justice has increased in Bangladesh, and that's primarily because we don't have the required statistics to make that kind of comparative analysis. I mean, mob justice statistics aren't really that common, but crime statistics are. And sadly, the Awami League regime had stopped publishing crime statistics on the police website after 2019, presumably after they found that researchers were putting that to use to criticize the law and order situation. So what we're sort of left with is our sense of crime rates is very much driven by news reports. So the more certain cases get reported on, the more we think they're happening, but we don't actually know if that is reflective of the actual increase in crime rates or incidences, or it's just that now a particular media house has chosen to report on that crime for whatever reason. Usually it has to do with some reasons of sensationalism and being able to monetize from increased public interest in a particular issue. And also, not to mention, now they're enjoying a level of freedom of expression that has been unprecedented for at least the past a decade or so. So there are a number of variables here which could contribute to this perception of increase. But going back to the question of mob justice, I mean, again, it sort of is linked to I think there's something intuitive about wanting to resolve wrong within the space where the wrong happened. And that's where, so that intuition in itself is not like something problematic. So that is actually the intuition which would allow for restorative justice to be made possible or palatable to the public. What's wrong is when the people want to resolve the crime or wrongdoing within the community it has occurred, but do not have the options to do it in a manner that is rights compliant, because there are no formal restorative justice mechanisms available. So then they sort of take matters into their own hands because they have no trust that the police or the court will be able to deliver what is considered fair or a just outcome. And they have good reasons to suspect that, right? Because by and large, public trust in the judiciary has reached an all-time low because of the way that it was weaponized again by the former regime. So we must acknowledge that it's not just there are the context which makes mob justice a sort of an appealing option. We must contextualize it, but of course, what can never be the case is people taking a law into their own hands and taking the life of another, which is what we've seen happen in certain cases where someone suspected of causing theft has been beaten, but later it was found out that the village elders who instructed his killing were actually demanding 20,000 taka from his family, and his family refused to pay, and that's when they decided to kill him. So that points to a darker reality, right? It's not some ragtag bunch of people who got so angry and killed him. It's very much, there's an industry here. There are people who make money out of informal arbitration, and when that monetary incentive is denied or suppressed, they then punish because they can. So that's another piece of the puzzle we need to figure out, and why it's important to sort of have a list of offenses. If they're not so serious that they need to go to court, allow them to be resolved within the community through restorative justice processes. If they're very severe, like murder, rape, and other forms of offenses which requires the state's intervention, then divert those to the court and the formal justice system, but again in a manner that is rights respecting. So that is how most modern legal systems are attempting to deal with strike a good balance between formal and informal justice mechanisms.
Mm-hmm. Thank you. Very important perspectives. And I think rights and dignity have to be at the center of all of this. So thanks for underscoring that as well. For those of you who are just joining now, just wanted to quickly point out that this space is shareable on X. So if you could share it with your communities, and also the YouTube link is to the Bangladesh America Alliance website. You could share that as well. And feel free to type in questions into the chat because we will be taking some questions after this. So going back to some of the current issues, Takbir, we all are also following these reform recommendations that came out of the different commissions. There have been recommendations for police reform and judiciary reform and a whole host of other economic and other reforms as well, which I know that the parties will be discussing in terms of where there's consensus. So just looking broadly at some of these reform recommendations, I was wondering if you had thoughts on which ones of those you think are good steps in the right direction, and where there could be some gaps that we can think about as well as we're thinking about reforms.
Right. So I haven't actually had the chance to sort of go through the Judiciary Reform Commission sort of report in full, but what I was very keenly looking at was the suggestion for an independent public prosecutorial service, because that has long been an criminal justice, one of the top criminal justice reform agendas that any expert or any sort of reform-oriented groups have sort of suggested. But sadly, I couldn't really find any mention of that. There is some suggestion of establishing an independent criminal investigation authority, and there's also this section that deals with depoliticizing the judiciary. But that is precisely, I think that's the first thing that needs to happen, that we need to have an independent prosecutorial service. And by that, I mean there needs to be a public prosecutor who gets to decide when the criminal justice system gets involved in a case, right? This is a matter in most advanced legal systems of prosecutorial discretion. So someone who has been vested with the power to determine when the state should use its resources to, sort of launch the criminal justice system in a particular case. By and large, in the history of Bangladesh, this power has been synonymous with the executive, and that's what allows the judiciary, that's what allows the criminal justice system to be weaponized and politicized, because there is no wall of separation. So if the prime minister or a minister or anyone that's close to the ruling party thinks someone needs to be punished, they have open free reign over the criminal justice system. That's what an independent prosecutorial service would sort of help prevent from happening. Now, the question is, how do we sort of, there are two ways to go about it. You can have prosecutors who are part of the civil service, and then they are sort of appointed through a merit-based recruitment system. Or you could have a prosecutor that's directly elected and accountable to the public. And that is what the situation is in most states in the US. So, then it's a matter of popular will and popular trust. So there are these models available, but by and large, that needs to be part of the reform agenda. Interestingly, Awami League, when it came into power after 1/11 in 2009, had this as one of their promises. And then in their last 5-year plan, they also had it, but it's never seen the light of day. It's just been an empty promise, and there's good reason why. No ruling party would want to give away this power that they've enjoyed for so long, which is being able to decide whom to punish and to what extent.
Mm-hmm. Yeah, that's why this the issue of depoliticizing the judiciary is so important. I was wondering if you thought that there were some steps that were taken since July, August with regard to the judiciary that you thought were positive, and we did make some progress along those lines.
I mean, again, reforms within the judiciary are very difficult to sort of keep up to tabs with, primarily because of how traditional our sort of knowledge sharing platforms within the judiciary are. There's much to be done by way of digitalization, but there have been some reports of courts sort of giving out punishment to offenders of egregious crimes. So I think that is one aspect that the media could focus a bit more on, in terms of publicizing cases where, that have actually resulted in some kind of outcome or a punishment, because that helps build public confidence. And the judiciary could sort of also digitalize records. I mean, we have that to some extent with the Supreme Court, but not so much with the district courts. So that people have means to sort of keep up to tabs with what's happening within the judiciary, rather than being completely reliant on sort of news agencies to report through whatever arbitrary mechanism they're choosing which cases to report on. And it also sort of helps with transparency. So right now we only get sort of access to judgments based on what certain group of law reporters decide to report on, and that again is highly arbitrary. There's no sort of objective criteria. So making information more accessible in an age where it's quite easy to do so would be a first step. And I think there is now, like, the judiciary now is more open than ever to some of these changes, because the interim government has sought to sort of depoliticize it to some extent.
Mm-hmm. Yeah, really important perspective. And in terms of the digitalization, I feel that that's something that doesn't get talked about quite a lot, but there are some really strong literature around digitalizing these public systems, record keeping, and starting from medical records to legal records and everything, and how that also can cut corruption, right? Because sometimes if things are stored in a robust sort of IT system, it's hard to game the system and pay off people to change the information, et cetera. So there is a very strong link to just digitalizing a whole range of state systems and reducing corruption in the system. So I'm glad that you're underscoring that as well. And then also coming to this issue of the trial process itself, we talked a little bit earlier about this issue of access to justice, and there's building public trust. So I think this issue of bringing perpetrators of rape to justice has obviously been top of mind for a lot of people, and this recommendation of expediting this process has also been received well. There is so much public outrage about these issues, and I think that the interim government did the right thing by stepping in with the recommendation on that. So I was wondering if you think that's really realistic in our current system in terms of expediting some of these trial processes. I think they've set some deadlines in terms of how soon these investigations need to be completed and perpetrators are brought to justice. Do you think that this is achievable? And if so, why or why not?
But particularly in relation to rape, these deadlines have existed, at least as far back as 1995 in the Violence Against Women laws. Like, these laws have already prescribed quite strict deadlines with relation to investigation and with relation to trial. So the problem has never been the lack of such directives or like time bars. What has been the problem is again, lack of institutional capacity. So the Rape Law Reform Coalition, which is formed of at least 17 human rights organizations, that was formed in the backdrop of the 2020 protests against rape, have highlighted a number of reform proposals for the then government to take into consideration, and which now the interim government should take into consideration. And one of the main sort of needs there was so none of these, for instance, was like, we need speedy justice, because there's a real risk to fairness if there's an sort of disproportionate focus on just increasing the speed without sort of looking at the systemic issues which prevent justice in the first place. So one of this is like a victim and witness protection system, right? So rape is an act of power disparity in most cases, and that power disparity can be used to keep victims or intimidate victims once they've decided to file the case. This is where an institutional witness and victim protection system would be quite crucial to avert that risk. And this is something that the Law Commission had, suggested back in 2007, but again has remained sort of in the books. The other thing is, there has to be like a national compensation fund that is able to compensate victims of violent crime, including rape, so they're able to sort of meet the immediate costs that are associated with being victimized, through violent means. And there, of course, needs to be training of judges, and the definition of rape, for instance, is still by and large the colonial definition that we inherited. So that needs to be broadened so that all victims of rape can actually seek justice. And here, I must note in particular that male victims of rape, unless their children, have no recourse to the law. And there has been another case that was reported recently where a man was raped, but our laws would not recognize them as a victim of rape because of the gendered definition that we inherited from our colonizers. And then similarly, transgender victims of rape would also be in a sort of legal gray area because of the gendered notion of rape within our laws. So there are these substantive issues as well as alongside the institutional gaps. And finally, and this is perhaps the most difficult to convince people, it's that we actually need penalties for rape in our current laws to be made more proportionate. So there is a crucial principle of any criminal justice system is proportionality of punishment. A judge should be able to give a sentence or punishment that is in line with the gravity of the offense that has happened. So some rapes are more violent than other rapes, right? Child rapes are very much more violent than date rapes. So there cannot be sort of an equivalent. Like what has happened in our laws is there's a mandatory minimum life term. I'll say that again. There's a mandatory minimum sentence of life imprisonment for any rape case. This, to my knowledge, we're the only country to do this. This is just bizarre. This allows no judicial discretion. So any case of rape, like if the judge decide that rape has happened, the only option they have is to either say that the person needs to be in life, like subject to life imprisonment, or the death penalty. So they kind of have, like, the judges we've spoken to have said that we feel like our hands are tied. So I may remind our viewers that life imprisonment is the most severe penalty in law in most countries that have done away with the death penalty. And that, we are saying, is the lowest available punishment for rape. So what that does is that leads to higher acquittal rates, because severity of punishment has an inverse relationship with conviction rates. So judges feel like even if they feel rape has happened, they feel it's not serious enough in this case to warrant life imprisonment. So they would rather acquit rather than convict. So that is why, acquittal rates in rape cases remain as low as, 3% per some estimates. So we need to recognize that the judges, if we want them to convict rather than acquit in rape cases, they need to be given the basic power that any judge has in any functioning legal system, which is, ability to give proportionate punishment.
Mm-hmm. Yeah, I think we need to have a longer discussion about the proportionality issues, because I think that the default is just to do things as they were, and some of these are inherited from the colonial systems, as you mentioned too. So I think that as we're kind of thinking about how to move the country forward, we need a discussion on all of these issues in terms of how to kind of bring justice in the right way and ensure that the people have fair access to justice, no matter how egregious the crimes are, right? That is kind of our way to a more democratic, more progressive system as well. Moving into this issue of this punitive system, and you mentioned about the severity of the punishment. Just also want to get your view of the death penalty in the context of Bangladesh, and there have been some discussions about that. So what are some pros and cons of having the death penalty, and broadly, just not just kind of in the case of gender-based violence, but overall?
Well, one would be hard pressed to find any pros of having the death penalty other than appeasing populist punitive sentiment. So, like any sort of criminology 101 class will tell you that the death penalty can be justified on three rationales. The first rationale is retributive, like the retributivism. So, eye for an eye. If you've killed someone, you deserve to die. It's hard to sort of argue with that logic if death of the victim has actually happened. But what is one way to think about retributivism is that we need to understand that there's a real risk of wrongful convictions. And it's happened around the world. It's happened in Bangladesh. It's even happened in the US, which has, far more resources and sort of put like towards the justice system and towards the death penalty cases than Bangladesh currently does. And by wrongful convictions, I mean there have been cases where people have either been sentenced to death or have been executed, and subsequent DNA evidence exonerated them of the crime because it was found that they were actually not the person who committed the crime. So as long as the threat of wrongful conviction remains, I would propose to retributivists that that eye for an eye presumes that every time you're using the death penalty, that it is possible to determine who was behind the crime. But sadly, our reality from decades and decades of practice and research so that's simply not true. The threat of wrongful conviction persists, and that is simply not you cannot authorize a punishment that cannot be undone. So that is the one way to sort of reason with retributivists. The other rationale, which is quite prevalent in Bangladesh, is the idea that death penalty deters crime. Now, there are a number of academic studies that have been done trying to sort of determine whether death penalty has a specific deterrent effect on crime. And sadly, sadly for people who want the death penalty to be in existence, the conclusion was that it doesn't. That using death penalty as opposed to other forms of punishment like life imprisonment does not have a special deterrent effect on levels of crime. It does not have a special effect on making societies safer. So, these types of research are difficult and expensive to conduct. So the one that was conducted most close to Bangladesh was one between Hong Kong and Singapore. So Singapore being one that actively uses the death penalty and Hong Kong being one that has had a moratorium on its use. But they have comparable levels of socioeconomic, progress. But one used the death penalty, the other didn't. There was no specific impact on crime rates in Singapore, for instance. So that is another, so that deterrence logic or utilitarianism is again does not hold up to empirical scrutiny. So the third rationale is public opinion, that we should impose the death penalty because the overwhelming majority of people want the death penalty to be used for certain crimes. Now, if public opinion is based on misinformed perceptions of the utility of death penalty, which is by and large a lot of people just automatically assume the death penalty has a deterrent effect, then how valuable is that public opinion, right? We should do more to educate people that the death penalty does not actually have a unique deterrent effect. And we should also educate them about the fact that there is a risk of wrongful convictions. And most importantly, we would do well to remember how the former regime used the death penalty to eradicate political opposition, right? So really, how much power are we willing to sort of sign away to the state? If you say the state can take away your life, there's really nothing much left by way of conceding our sovereignty, conceding our liberation. So those are three rationales on which death penalty is typically justified, and I've attempted to sort of suggest why ultimately they don't stand on strong grounds. And finally, I'd just like to remind that international law itself reserves death penalty only for the most serious crimes rule and subject to the strictest evidentiary standards. And our laws do not meet either of those requirements because we have prescribed death penalty for a number of cases which are simply not the most serious crimes.
Mm-hmm. Yeah, thank you for that. I guess kind of talking about public opinion and this sort of notion of populism, I've always been curious about what are some really good ways to educate the public on these issues, because sometimes these are just notions that have kind of continued without question for a long time, because people haven't had the right level of trust in the state, which has been kind of a perpetual issue in Bangladesh. So kind of moving forward now, as we're sort of building, we're at the start of kind of building hopefully a new system. I'm wondering if you have thoughts on how to kind of change public opinion on these things, or to sort of move towards restorative justice and away from highly punitive systems. And is there a role for the legal community? I saw that after the July Revolution, there was a group of lawyers that started the Anti-Discrimination Forum for Lawyers. So I don't know if there's thoughts around kind of how the legal community can take leadership, and maybe there are other public opinion leaders as well through media and other avenues can influence like a rational discussion on these issues. So just wondering if you have had thoughts on that based on studying other contexts and countries, or any kind of overall thoughts on Bangladesh.
Yeah, I think public opinion definitely needs to be informed by empirical realities. So one thing would be for government officials or justice sector officials to sort of publicize some of the issues that we've just discussed about, like what. Like in relation to the death penalty, as I mentioned, like the actual statistics which show that it doesn't work. There's also a role for historians to play here to sort of remind the people about what justice used to look like before we experienced colonization. So if we had more historians talk about how community-based justice systems used to work, in the pre-colonial era, then we will know that this increased reliance on the carceral state, or like imprisoning people or killing people through the state machinery, is very much a modern phenomenon, and very much one that is rooted in colonial subjugation, and that our notions of liberation should also be informed by not just being able to ouster the last authoritarian regime, but be able to sort of undo everything that our initial subjugators, which is the British colonizers, sort of left us with. So being able to restore status quo that reaches far back into that bit of history. And as I said, there are a number of countries which have invested in restorative justice programs, learning from them. And UNDP and certain development partners in Bangladesh have also funded restorative justice programs. But the great irony is that much of this funding also comes from the British aid agencies, without any sort of acknowledgement that Bangladesh did have a default restorative justice system back in the day. So that kind of does not help the legitimacy of these programs, because people think you are imposing Western models of doing justice on Bangladesh, which are not fit for purpose, which is why these need to sort of be historically informed. So, people perceive them as being more legitimate because they are indigenous to our culture. And I mean, finally, I would sort of also remind people of the basic principle that you are innocent until you're proven guilty. So there's a lot that is left to be desired by way of our reporting of crime, because we do not respect this cardinal principle of the criminal justice system. We think as soon as someone is accused of a crime that they are as good as guilty. So we've referred to mob justice cases, but something related to mob justice is trial by media. So there are certain safeguards that need to be in place, which provide certain protections to the defendant, and that is very much an aspect of the right to fair trial, which, by the way, is an absolute right and needs to be upheld according to our obligations under international human rights law. Those are some of my quick thoughts on that.
Yeah, thank you. Yeah, the role of the media, I guess we can't possibly understate it. It's so important. And we've seen cases recently where the media has been disclosing names of people on both sides, and that also kind of inhibits the right to fair trial and the whole impartiality of the whole process, right? So I think that the role of the media is so important, and we should probably have another episode on media accountability, because it's at the root of a lot of things that we're seeing going on right now, including even sort of misreporting of some of the incidents that are happening. So we do have some time for questions, and Tagbir, thanks for engaging in this really important discussion. So I know that on Spaces we have a way for people to ask questions. There might be people who are part of the community also have specific questions that they want to ask first. So while we're collecting questions, I wanted to turn to Kausar Bhai, who is the convener of this series, who gave the remarks in the beginning, to maybe pose the first question to Tagbir, if you have been thinking about these issues, if you have a burning question you want to ask.
Actually, I have two very specific questions which some of our ex-friends have been posting to me for the last 45 minutes. So let me start. These two questions are, everybody keeps talking about that in X, and they keep on circling back, especially the BJP handles and Awamu League handles. They're always talking about this first one especially. So the first question is, right after the interim government came into power, we saw a lot of Islamists, getting out of jail, right? So this whole visual optics came up that, this is Islamist government, they're just letting everybody go. So what is the actual story behind that? If you could share that, from your perspective, right? So like, were they being held without the due course of law? I mean, what actually did happen, right?
Right. I mean, first, I must qualify that these are highly case-specific questions, and it's sort of impossible to answer them in the abstract without, reference to specific cases. But one could infer, based on the fact that 80% of the detainees in Bangladesh were pretrial detainees, that as I've just established, that they have a constitutional right to bail, and there are only certain grounds in which you can hold someone in pretrial detention, and that is if they're a flight risk or if they pose a danger to society. And so the fact that many people left prisons which were already unjustly holding a good number of prisoners is not, in and of itself a flagrant breach of sort of the rule of law. But what is, of course, worrying is that there were a number of jailbreaks that were happening, and that there was a complete sort of rupture there. And one could ask, the more important question to ask is why that occurred, and why there is there seems to still be a lack of response from the police in certain areas. And here I might point to a risk that many have said, that because of the partisan infiltration of the police and other penal institutions, some have actually suggested that they are willingly sort of retreating, so that the law and order deteriorates to such an extent that renders this interim government illegitimate. So there are those theories there as well. Of course, without sort of caving into either extreme, what we can hope is that while the police and the judiciary is being depoliticized, that those who are currently holding those positions will do what their jobs require them to do, and which is to ensure that the law and order framework is upheld, and that so I guess that is one way to respond to this question without knowing specific.
Right. It's specific, but again vague, right?
Yeah.
For that. Okay. So then I'll move to my second question. Is like, since day before yesterday, the issue, with the student political party, some of the leaders were saying how they want to ban Awamu League, right? So this whole discourse going on again. This is started all over again. So what are your thoughts about banning a political party?
I don't think a blanket ban on a political party is necessarily something that can be reconciled with the right to freedom of opinion and expression and the right to assembly. So if we are holding ourselves out to be a country which now seeks to uphold basic fundamental human rights, and one could refer to the International Covenant of Civil and Political Rights, which we have ratified, then such a blanket ban cannot be sort of reconciled with those international human rights law obligations. And here, I think one thing that's related is also the huge number of cases that were filed against Awami League members, right? The use of the criminal justice system against them in the similar manner that they used against their political opponents. There's no denying that a large number of cases that were filed in the immediate aftermath of the regime's collapse are quite dubious. They are like filing cases against individuals who could possibly not have committed the crimes which they are being accused of. Now, typically in a crime, you need someone who has done the act and has had the mental intention to do the act, and that is what constitutes a crime. Now, cases like that against Shakib al-Hassan, for instance.
I was going to bring that up, a very specific case,
Yeah.
right?
And certain other high-level Awami League officials who, yes, they did serve the Awami League regime, but they were obviously not the ones pulling the trigger. But there is, of course, that is not to say that people who didn't pull the trigger formally cannot be held to account. They can, through the notion of command responsibility. Now, command responsibility means that someone who had effective control over the people who were pulling the trigger. So who was ordering the security officials who were pulling the trigger. Now, a lot of the people who have been implicated in these cases are high-level officials who are part of the Awami League ruling elite, but they may not necessarily have had the command responsibility either. So the guiding question then there is, are we going after those who truly had command responsibility? And that should really be something that, determines which of the Awami League leaders are held in detention and those who aren't. But sadly, that does not seem to have been a specifically limiting factor, and there have been, it does look like a witch hunt of some sort.
Right. So, what do you think is the way out for Bangladesh? Because I feel there's a status quo here, right? And a lot of people are saying that there should be some sort of truth and reconciliation, like they had in South Africa. What are your personal, ideas about that? That's my last question.
Yeah, I mean, of course, something of that nature would be extremely important in a post-conflict. I mean, so typically those happen in post-conflict societies which have experienced a protracted conflict and, sort of between two competing factions or more. For us, what has happened is, of course, an extreme act of violence and an extreme level of killings that happened in the course of 2 weeks. So we don't necessarily have that protracted nature, but if we look at the kind of violations that took place over the course of the Awami League regime, then in that sense they were protracted. So there are similarities, but there are also differences from those conflict settings. And another example would be Colombia, where a similar sort of transitional justice mechanism was set up with assistance from the UNDP. What we need, yes, we do need something similar, and we actually do need to put victims' voices at the center stage. The individuals who lost the 1,000 or so protesters who were killed, their family members need to be at the forefront. They need to be articulating what it means for them to have justice. The individuals who were maimed for life, like the 20,000 or so people who are injured. So we need to be speaking to them, and we need to sort of also recognize that if we wanted to punish every single person who was involved in the purge, then we will be seeing a lot more blood. And if, as a country that has already experienced this much bloodshed, how much more bloodshed?
No.
We really want
Right.
to get more blood.
The idea of that, I spoke to another human rights lawyer a couple of weeks ago, and the concept that you're saying, that the command responsibility, right? It should be those people who take the brunt of the responsibilities, right? Not the person who shoots the gun, but actually the person who, gives the order, right? That's what it should be. That's where we should cut it off. If I got you correct, that is where the philosophy should be, right? And anybody down the road can have, maybe, do some sort of reconciliation and let them go? Maybe like something like that?
I mean, so there are, again, differing levels of responsibility. There are people who may have had command responsibility, who are the higher ups, and within those who received the instructions, we've seen a video of a police official who was going after people with a baton, but he was not actually hitting the protesters, right? So now he's being celebrated as a hero because, he tried his best to follow the orders, but he also did it in a way that did not harm the protesters. So if we went in a retributive system that held everyone accountable in the same way, this individual would also be punished, right? So I'm sure that there are other officials who realized that they were under the obligation to carry out the orders, but they sought to mitigate how to do so. So that kind of nuance can only come about if such truth and reconciliation commission is set up, and if we are willing to understand that culpability can take different degrees, and that not everyone who was involved necessarily deserves the same kind of punishment. Or so again, it's for the victims to sort of dictate the terms of the trajectory it should take, which is why we should be listening to them. And I understand that they already feel quite sidelined.
I do want to to some other questions as well. So Abir, who's part of the community, also had a question, and then if we may take one or two from the audience if there's time. So Abir, did you want to chime in?
So Takbir, I think the question I have is about civic and legal protections. What's necessary right now? Because going forward, there's so little confidence that any of the actual legal reforms, for instance, even the reinstatement of the interim government provisions, how can we have that confidence that that will actually happen? And also, from an activist standpoint, what can we do as a civic community to make sure we keep pressure on the government and the new government after the elections to make sure these changes are permanent? So I will take my question off here.
Sorry, just to confirm, the question was, how can we reinstate the constitutional provision which allowed a neutral interim government to oversee elections?
No, the question was about what kind of legal and civic protections can we pursue at this point of time to ensure that some of these changes are permanent. An example would be the interim government provisions that are even being questioned right now. Some in the BNP may be saying that they may not be necessary for the next election, right? So what can we do as the community to keep that pressure on that these reforms are not temporary, or these reforms are serious, they need to be protected, they need to be talked about, and that pressure needs to be applied and continued for our democracy to mature, to survive, to grow?
Well, so the thing is, I mean, the most permanent structure of the legal system is the Constitution, right? So people, like most countries, when they sort of form the nation state, they have a constitution with the idea that that is going to be the permanent rubric that's going to guide every other act of lawmaking. Now, we had a constitution in 72, and in the past 54 years it's been amended 16 times, which is roughly once every 3 or 4 years. So we need to so just having something on paper, even the Constitution, is not going to safeguard people against the threat of executive amendment or executive overreach, and that's really where the centrality of public protests and people power through presence on the streets, if things don't go our way, is important. And I think we should be very vigilant about early signs of authoritarianism, right? Like Awami League regime did not start off being as authoritarian as they ended up being, right? Their first tenure between 2009 to 2013, by and large, was quite restrained in principle, in comparison to what was to come next. Of course, notwithstanding the BDR massacre, which was probably the high water mark of authoritarianism during that era, but being attentive to those early signs, not waiting to sort of hit the atrocity to affect us directly before we raise our voice. And by this I mean, let's not forget the fact that the Chittagong Hill Tracts remains the most militarized region in Bangladesh. A lot what happens to us, i.e., those in Dhaka or those in like the main cities. There's a saying that the testing ground is the Chittagong Hill Tracts, and once that becomes acceptable, then those same forms of oppression is then extended to quote unquote the mainland. So turning a blind eye to what's happened in Chittagong Hill Tracts, going on lavish, lofty vacations in resorts which are by and large built on occupied indigenous land, is certainly not the way to go about securing us from an authoritarian free future. So being attentive to those threats, and another threat could be, the the erosion of workers' rights. Before they shot student protesters, they shot workers who were protesting for a basic living wage in November 2023. How many of us were, concerned about that? How many of us are friends with people who own those factories which deny workers a basic living wage? So if we introspect, authoritarianism does not come as an abstract random force from the sky one day. It's something we make our peace with progressively, and we have varying degrees of complicity as well. Do we own resorts in Chittagong Hill Tracts? Have we gone on, visits to Chittagong Hill Tracts where we've stayed in those resorts? Do we, own factories which subjugate workers and deny them minimum living wage? So, these are some of the questions we need to ask ourselves. Like the Awami League bogeyman is great, but a more honest assessment of how we got to where we are is also asking ourselves how much we said was okay before it affected us directly.
Mm-hmm.
Thank
Well
you.
said.
That was a great response. Yeah, go ahead.
Well said. And Abir, thanks for asking. I know we're at the end of our time and we wanted to wrap up within the hour. So I think we've got some great takeaways. And if folks want to engage on this topic, feel free to continue to do so on X. There is a community discussion on past webinars on X as well that you can just start. And Tagbir, I think in terms of kind of your final words, you've made the case strongly about restorative justice, moving away from punitive systems, setting up strong, impartial systems that there's public support and trust for, and how all of that is key to making sure we don't devolve into the same sort of vicious cycle that we've had for years under both political parties in the past. In terms of kind of building capacities, you've made some recommendations as well for the justice system. So any final word that you want to leave us with before we finish? And then I just want to kind of come back to our next upcoming episodes as well.
No final words except to say that, question the powers of the state that have become increasingly normalized. It is not normal for the police to arrest people without warrant. It is not normal for people to be denied their right to bail. It is not normal for 80% of the prison population to be in pretrial detention. And it is not normal for us to prescribe a mandatory minimum of life imprisonment or the death penalty for crimes which do not meet the most serious crimes threshold. So these things are not normal. It is a sign of an authoritarian penal system, which still has a longer life than authoritarian regimes. Getting rid of authoritarian regimes is not the end of the battle. The end of the battle is truly liberating ourselves from these modes of subjugation.
Mm-hmm. Thank you for that. This has been a really interesting discussion, and hope to continue to engage with you on these in the future. So as for the Alliance, the Bangladesh America Alliance, I believe there's another episode with Ashik Chaudhary of the Bangladesh Investment Development Authority on April 12th. And we hope that you'll continue to engage. I also am working on these issues separately through other projects, and I'll be following along these discussions as well on this community. So just wanted to turn to Kausar Chaudhary for any final thoughts before we wrap up, and any other announcements that you'd like to make. And thanks to our viewers for tuning in and engaging with us. I think you're on mute, Kausar bhai.
Sorry. Thank you so very much for coming in. We at the Alliance, our target is to bring in wonderful and talented and intellectual speakers like yourself to have a good conversation, and that so that our listeners and our followers can take away something from every one of our episodes. So whatever you said was very insightful, and I hope that we can call you back at another time, because so many things are happening right now in Bangladesh, and there may be so many other issues developing. So maybe you'd want to come back and enlighten us again soon. So thank you again. And just saying that about Ashik Chaudhary, yes, we are having him very soon. That should be right after the BIDA event. And we will also be having some other podcasts, which we will be announcing soon. Thank you very much, everybody. Does Shamruk, you want to have some last words tonight?
No, thanks for hosting us. And I thought this was a really important discussion at this juncture in time. So thanks, Tagbir, for making the time, and looking forward to your writings and discussions on this subject. And thanks to the team that put this together. Thanks, everyone.
Okay, great. Okay, then we're signing out for tonight.